the today's topic is very topical, given that COVID-19 has, like never before, greatly reduced access to justice in Nigeria. So it's quite needful for us to examine what is going on, where are we, why are we at the levels we are regarding access to justice. Can we do better than we're doing, and what are the steps we take on the part of the judiciary, on the part of the bar, and even on part of the government, because government principally owes the duty to ensure that its citizens have a right of access to justice at any given time, no matter the prevailing situation. What is going on in Nigeria should also be looked at. What is going on in other climes in the developed and the developing world. Where exactly are we situated? Are we lagging behind? Are we average? Or are we below average? I don't even want to say are we excellent, because I know we are not. So we need to examine all this, hopefully come up with solutions that would move us forward and into a better place than where we are and where we're coming from. And so I look forward eagerly to listening to all the speakers. I look forward to the question Q&A, and knowing the pedigree of AAL, I can urge you all to fasten your seatbelts, because very exciting hour or more is ahead.
Thank you very much, Honorable Attorney General.
Thank you very much, Leonard Silk and Honorable Attorney General, Lagos State. Do we have Mr. Ote back with us now? If not, I will call upon I'll call upon Mr. Femi Fajolu to give us.
Hold on, please, Mr. Shitabe. Mr. Ote, are you on? Mr. Ote, we still cannot hear you. How did you join the webinar? At the bottom left side of your screen, there is a microphone. So you need to click on that to enable us hear you. Okay, I can see that you are unmuted. Can you say something so we can know whether it's working or not? We still can't hear him. Let's go to Femi.
Okay. Yes, Mr. Femi, please give us just apology. I believe Leonard, the distinguished Honorable Attorney General of Ekiti State is in our midst. So we welcome you into our midst. Bumi, can you please do the introductions properly? I'm not very good at this.
It's our very great pleasure to welcome to today's webinar the Honorable Attorney General and Commissioner of Justice, Ekiti State, Mr. Olawale Fabunda. He is a very eminent crusader. And in fact, what we're discussing today is his specialty. And he has been a part of the justice sector reform team from 1999 to date. So, Honorable Attorney General, welcome. We're looking forward to your participation in today's meeting.
Thank you for having me.
You're very welcome, sir. Apologies if we put you immediately on the spot as you come in at the right time. We've just heard from your learned brother, Honorable Attorney of Lagos State, give us an insight into the subject matter of today. As you would have read from the press releases, we're dealing with access to justice, and from the perspective of delay in the dispensation of justice, without which there cannot be justice, as we know. The Honorable Chief Justice of Nigeria has actually put legal practitioners on the spot, because he identified the various stakeholders as being responsible for delay, but he particularly put us on the spot. We are here to address, these challenges and say, come up with creative solutions. How do we tackle this, even as lawyers, and be the right example to champion the cause of speedy justice? So just give us a few words, about 5 minutes, to take us into, which will be a basis for question and answers, as we always do at Ask a Lawyer. Thank you very much, sir, for honoring us.
Thank you. I'd first like to congratulate and thank Ask a Lawyer team for putting this together. It is very timely, especially now. The issue of access to justice is one topical issue, especially given the COVID-19 pandemic. You would have heard, at least in the last 1 week or so, my friend and brother, we had approached the Supreme Court to further clarify issues of access to justice and what is the role of lawyers and judges in the COVID-19 situation as it affects our courts. Regrettably, the outcome was not what we had expected. We thought that would be an opportunity to have clarified where we are, particularly as it relates to the use of IT and access to justice. But anyway, we are moving forward. We are having a conversation between us on what to do, because COVID-19 apparently does not seem to be going anywhere. The numbers appear to be increasing on a daily basis. And whether now or in future, we definitely have to find a solution to enhancing access to justice, even given the state of COVID-19. Now, as far as the topic of conversation is concerned, we all have roles to play. Access to justice is not a single institution agenda. The judiciary, lawyers, as you have said, key justice institutions, police, prison, ministries, justice, we all have roles to play. The organized NBA, absolutely. Yes, in the past, there's been lots of complaints about the role of NBA in making progress with issues of access to justice. The issue, and I don't think anybody can possibly deny that, is that there are too few lawyers working in public interest. The leader is not, when I talk about leadership, I mean there are very few that are working in interest or in public interest. It cannot be about Femi Falanas, it cannot be about backpass. And maybe one of the reasons we have really not made tremendous progress in that area is because we don't have that leadership. With respect to the NBA, he also has a very crucial role to play. Thankfully, now we are in NBA election period. It has been interesting to listen to the three candidates are offering. I have been particularly interested in what they have to say about what they are going to do to promote access to justice. You may know that the NBA has a pro bono declaration which commits the legal profession to doing public interest work. Regretfully, that's not of the way it was planned to do. There are also a number of committees. I see that in your flyer, there was this issue of whether to divide NBA into sections or groups to these issues. I don't think that is necessary. The existing committee, there's the Admission of Justice Committee, and other committees outside the three sections of the NBA. There are specific committees. But the reason why, again, we have not had or felt the impact of this committee is because it has not worked as we say. So going forward, whoever emerges president of the NBA will take us forward properly in a manner that places the legal profession at the heart of justice issues in this country. So I thank you for having me. I will look forward to hearing what others have and will contribute from then on. Thank you.
Thank you very much, Leonard SAN and Honorable Attorney General of the Ekiti State. Thank you for your insight into the subject matter of today's roundtable. At this point, I'll hand over back to our host, one of our hosts, Mrs. Bumi Ibrahim.
I'm going to go back to Mr. Ote. He was having issues with his laptop, but he's using another device now. Mr. Ote of Access to Justice, an NGO that is devoted solely to the matter that we are discussing this afternoon. Mr. Ote? It seems he has not. Mr. Ote is not with us.
I think he's back, but I'm going to ask him. I'm asking him to unmute himself. Apparently, he transferred to another laptop.
He's still on. He's still not on. I did ask maybe he had a son or a daughter nearby that could assist him. It seems not. Okay, he's asking for a few more minutes. So
Right.
Let's go to the next person.
Okay, Mr. Femi Fajolu.
Hello, everybody.
Hello, sir.
Good afternoon.
Good afternoon, sir. Just give us an insight into the subject matter of discourse that will now be the foundation for our Q&A interactive session.
Yes, first of all, I want to thank everybody for this session. I think it's about time we take this issue seriously. I'll give an example of a case, a personal case I have. It has to do with the piece of land that we had at Lekki that people over. And we've been in court for about 3 years. And not even started trial. This is a case that I'm handling with another law firm personally because it has to do with me, and it's like an estate thing. We've been in court at every instant that we have been. 3 years, we have not started trial. That's to tell you how bad it can be. Justice delayed is justice denied. I'm looking at a situation where we need a reform at every level, even from the magistrate court to the high court, court of appeal, and the Supreme Court. I believe we can start by departmentalizing the court. A situation where a judge takes all the cases, I think will not get us anywhere. I think we should have criminal courts like they have in some advanced countries. Let's have criminal courts that are separate from courts that will take shipping and intellectual property cases. Let's have criminal courts like in the state high court. Let's have criminal courts. Then let's have courts, civil courts that will take strictly contract. Because a lot of the problems we are having, we have issues of contracts that will hang on for so long. Sometimes it takes about 10 years from trial court up to Supreme Court. At the end of the day, the clients have forgotten about the case. You are just going to court. The clients are no longer interested in the case. So we're not getting anywhere. We need to do something about it. I'm happy that we have at least a minimum of 2 attorney generals today. We have the attorney general of Lagos State and Ekiti State, and I know that they can do a lot to move things, because these are not just attorney generals. The people are people that have been involved in the reform process, and there's a lot they can do. Moving the chief justices of this state to do a lot, including the Federal High Court. Federal High Court used to be, I said used to be because it's supposed to be a specialized court, but as it is today, it's no longer a specialized court. You can have a case at the Federal High Court and it takes up to 6 years without getting to trial, and it defeats the whole essence. So I think we need to start this reform at the magistrate court, the high court of appeal. I think even that the court of appeal, they should expand. They said in Lagos where we have just 2 courtrooms. In Lagos, we should have minimum of about 6 courtrooms because of the volume. Supreme Court, I don't believe that all cases should get to the Supreme Court, for God's sake. We should have a way of steering these cases, and the issue of leave or no leave is not working. Let's try something else. For now, that's what I have to say. Thank you.
Thank you very much, Mr. Femi Fajolu, for that insight into the subject matter of today's roundtable. At this point, I would like to welcome Inter-Amist, the learned senior advocate of Nigeria, Mr. Rotimi Oyedepo. You're welcome, sir. You're welcome, Inter-Amist. I will ask you to unmute.
Well, thank you for the privilege accorded me to be part of you. But let me set the record very straight. I'm not a senior advocate yet. And I know that with your prayers, one day, I will wear the shoe. Yes. But I'm not a senior advocate. Yes, thank you so much.
Imran Rolong Letini on your behalf.
that is the word has been spoken, so it will surely come.
Thank you, sir. Thank you so much.
You're welcome. You're welcome, sir. Is Mr. Ote? Is Mr. Ote?
No, he's not back. I've just sent him a fresh meeting invite, which he's going to use on the new device. So let's give him a couple of more minutes.
May I acknowledge and also welcome into our midst learned senior advocate of Nigeria, Mr. John Olusegun Odubela, former Honorable Commissioner. Please kindly unmute and give us your own, brief thought on this subject matter that we will be engaging on, sir. Mr. Odubela, you have the mic, sir.
Oh, I think
kindly unmute, sir. Right.
Yes, I think I'm having some difficulties here. I'm
We can hear you
fine.
very well, Shegun. We can hear you.
Oh, okay. Thank you very much. Good afternoon, everyone. The topic I think is quite apt, and we all know that with this COVID-19, that access to justice is also a bit curtailed, and that there is need for everyone, of course, to ensure that we all play our part so that at least the access to justice for everyone, both civil and criminal, are not hindered in any way. And of course, it's a pleasure to be part of this roundtable. And I just wish that at the end of the day, that at least a lot will have been achieved so that our legal system could move forward. Thank you very much.
Thank you very much, Leonard Silk, for those words. At this point, we'll check on Mr. Ote again. I'll ask him to unmute whilst I
I think we should go back to Mr. Jayago, Tokumbo Jayago.
Okay.
Mr. Guru, over to you, please.
Oh, sorry. Good afternoon, ladies and gentlemen.
Good afternoon, sir.
Sorry, I've been multitasking. I think Imran asked that I should give a quick synopsis about Ask a Lawyer. Correct?
Yes, please. Yes.
You've caught me off guard. Well, that's fair enough. I really can't remember. I think it's 5 years ago where we all came up with the idea, about 6, 8 of us.
Yeah, about 4 years ago.
5 years ago, yeah, we all came up with the idea.
4 years. 4 years.
4 years?
Yeah, 2016, April 2016.
You're going to help me along with dates and things.
Yeah, okay.
So a few of us came up with the idea that we needed to form an intellectual group where topical legal issues are being discussed. So we started with a WhatsApp forum, and we said specifically no jokes, no general videos, simply law-related issues and mostly topical. And we decided also that we wouldn't stay on the WhatsApp forum. We would graduate it and escalate it to what we're doing today. So I'm extremely pleased that we're not an armchair critic. We bring what we discuss on the forum, we bring it to live issues as we're having today. We've had, I think, 4 of these programs. This is the first one we're having online for obvious reasons. And I'm very happy where we've reached so far. We're expanding, and I'm hoping and praying that we get bigger than we are, and we become a good pressure group where when we speak, the legal profession listens. That's what I can say right now. As I said, Imran caught me off guard. I don't have dates and numbers, but that's what I could say off my head right now. But we're moving slowly but surely.
Thank you very much, Mr. Jayagu. I think you said it all. In those few words, you summed up everything.
Thank you.
Thank you so much for doing that. At this point, we will...
Sorry, Imran, I have Sheila Yojo who is asking a question. And I think the question is relevant to what we're talking about now.
Yes.
So Sheila, over to you.
Yes. So we're going straight into the round table now, the interactive session. And that's going to be kicked off by the first question by the speaker who's coming up now. Please, over to you. Unmute yourself.
Good afternoon, everybody. My name is Sheila Ojo. It is a first for me to be part of the Access to Justice Roundtable and platform. I'm here at the instance of one of your colleagues, a senior colleague, who gracefully gave me the link to join. I've practiced law like many of us, and I've often wondered, when will we get to El Dorado, and what are the challenges? How can we surmount these challenges that stare us in the face? And I've often looked at it from different perspectives. First and foremost, I think we require a major mindset change. And that mindset change, or to birth a paradigm shift, will affect not just the lawyers in practice, but it involves the bench. I think it also involves legal education in terms of the orientation and how we let lawyers into practice, because I feel that when somebody has spent 5 years learning a particular thing, it's difficult for the person to come out and want to change that thing. Now, I'll just break it down just briefly. When I talk about legal education, I'm talking about training on the ethical norms. I think being an employer of labor now myself, I'm beginning to see that it doesn't seem to be engrafted in the mindset of lawyers coming out of the law school today, as well as those who are in practice, which then takes me even to the core group of lawyers themselves. We don't seem to have a proper, we don't seem to have an enforcement machinery that really looks at putting disciplinary measures in place concerning them. We have the judges as well, the courts. I think our courts need to be engaged by this group and perhaps other interest groups to address some core issues. And I picked it off what Mr. Fajolu was saying. For example, he talked about the case that he has. One of the things that I have noticed in my experience is the interpretation that our courts put to the rules of court. So let us take written arguments, for example. One of the fundamental things about the rules of court that we have is that the courts are supposed to interpret it and apply the rules in a manner that ensures expedited hearing, to ensure that justice is done. Now, we're told to put in written arguments. Written arguments are supposed to assist the courts to understand where counsel is coming from before the date of the case. And a good judge, and I mean no disrespect to anybody, will typically have read it, so that when the motion or case is called, it is about asking, address me on this point, clarify this issue, which reduces the time. But we find out that that is not the case. Also, I also noticed that right of appeal. Somebody gets a ruling on the first day of the month, is an interlocutory ruling. The case is fixed for hearing proper 4 weeks after. 3 days before the date fixed for hearing, the aggrieved party sends a notice of appeal that it files about 2-3 weeks prior. And at the end of the day, the hearing cannot continue. We get to court, and this is a personal experience, a motion for stay has been filed, and you tell the court, look, the application for stay has been filed. Clearly, it is intended to frustrate hearing. If the court permits me, I can address orally. And I dare say in 10 minutes. I know that when a lawyer says 10 minutes, but I'm actually talking about a pure 10 minutes. And I will send authorities later if need be. The court tells me, go and file a written address. That means that I have to look at 7 days. The cost of that day is not dealt with properly. The client's case has not happened. A date has been vacated. 7 days is not a practicable window. So I'm going to have to probably bring an extension of time for me to file a response. My point is this: if those rules are to be applied assiduously, the way they're supposed to be applied, the court should sanction the other party and at least indulge me a bit to allow for me to do oral arguments, even if you're going to curb me to the 10 minutes that I ask for. But we find out that in that context, those rules have not helped to reduce the caseload of the courts as it used to be, even under the 1972 and 1994 rules. Then when you're talking about leave to appeal, which is what Mr. Fajuli says, and that perhaps is the last point because I'm not a speaker on this platform, I just thought to air these views. Leave to appeal is treated by our courts as though it is routine. And when you oppose an application for leave to appeal, either on grounds of the frivolity of the grounds of appeal or whatever, you are told that it is for him to exercise his right of appeal. Let him go and exercise his right of appeal. I think it is important for us to articulate the point very well, that they understand that where the Constitution imposes the requirement of leave, that means that there is no right of appeal. And that means that the court must look at the grounds of appeal very well to determine whether or not to grant leave. So I find that these are the little bottlenecks. Now, a system is only as efficient as its drivers. If you have a traffic gridlock at a four-way street and you decide that you want to put a roundabout there, that roundabout can only be effective where the drivers observe the basic rules of traffic that say give road to traffic on the left. If they do not, you will still have that gridlock. So we need to look inwards to ourselves, and the lawyers are not exempt here. I'm not casting any blame on the courts per se, because the lawyers also have to understand the concept of brief writing and address writing, and that's why it goes back to the law school. But then we have to ask ourselves, who are those that are going to guard the guards? We have presently an MBA disciplinary process that has not, in my view, been as effective and as efficient as it should be. These are things we need to look at. We need to look at access to justice in the context also of these jurisdictional problems. A man takes a case to court. Somebody raises an objection to the jurisdiction. I have an application to say, don't go down this building. That is the subject matter of the litigation. You then tell me or tell the court that because I am challenging the jurisdiction of the court over that case, then the court cannot make a preservative order. Needless to say, that building can go and be pulled down and things will happen. Of course, we have Ojukwu and Governor of Lagos State in the past, but how have those rules been applied today? So I think in summing up, we need to begin to look at ways to engage the courts, to engage counsel. Our disciplinary measures have to be in place. Our ethical norms, we have to up the ante. I once did a case involving QC in the UK, and we had a legal position that the QC refused to take and argue. Why? Because he's taking the direct opposite of that view in another case. We need to up our ante as far as ethical norms are concerned. We need to have our enforcement machinery in place. We need to engage the courts and sensitize and discuss some of these issues. It is not enough to do a transplantation of the rules in another jurisdiction, or simply because a practice appears to be exotic, we take it and then take it into our court system and expect it's going to work. The people who implement these things are very key. What the AG of Ekiti State and the Honorable Attorney General of Lagos has talked about, what happened in the Supreme Court in the course of the last week, speaks to the issues we're talking about. We need to embrace the need for change. Those are the few comments I have. Thank you for the time and room to offer my thoughts.
Thank you very much for that, Shay. From what you have said, I think you have actually hit the nail on the head. And that is why we're having this AAL webinar. It is lawyers talking to lawyers about how we can improve the process. And you talked about disciplinary actions on lawyers, because it is we lawyers that actually kick off the entire process. When somebody has a grievance, he briefs the lawyer to solve that problem, to find a remedy, to get justice. So how do we get justice for our client? Now, we need to be able to make it unprofitable for our colleagues to delay matters and to file frivolous actions. How do we do that? Do you report him to the disciplinary committee? How long does the disciplinary committee take to even hear the matter? Do you wait for your case to go on and build your case file, so to speak? Wait until the very end before you file a matter. So these are some of the issues that I think we will still be discussing later. Mr. Oche has found another laptop and he's ready to talk to us. So we're going to go over to Mr. Oche now of Access to Justice.
Kindly unmute, sir. I think what we are experiencing is one of the constraints, one of the major constraints of access to justice. You know, connectivity, infrastructures, and so on and so forth. In this post-COVID-19 period, that has been a major concern. You know, so I'm happy I can hear your voice, Mr. Ote.
Go ahead, Mr. Ote, we can hear you.
Can you hear me?
Yes, yes, sir.
Okay, finally, I am so grateful, and apologies for all the very, tough technical issues that have been experienced from my side. Really profound apologies to everyone, to all the attorneys general who have been able to join us, for all other participants. Because of the experience I've had, I'm really not sure anymore whether it's going to break. Can you still hear me?
Yeah.
I can hear you. Please,
okay.
Please go on.
All right. First of all, I'd like to thank Axel Lawyer for having me on the program. I think it's also a very timely topic that you have chosen, particularly so now that we are in the situation that we are in right now. So thank you so very much for having me. I've heard a number of previous speakers, so I'll probably have one or two things to say on some of the points they raised as we go along. But, to begin, we probably would acknowledge that even before the COVID-19 situation, we've had huge access to justice issues, costs, issues of integrity, corruption, issues of accountability, delays, several of them. I'm not sure whether we were making so much progress, to address some of those issues. But those challenges are infinitely magnified by the imposition of the lockdown as following the COVID-19 situation. So we are dealing with something that's bad, and now far worse. So it's the question really is, how can we come out from the complications that have arisen following the COVID-19 situation? We recall that the CJN has issued quite a number of directives since the pandemic broke out in these parts. And as far as I recall, the last one was the one of April the 8th that directed courts to attend to matters that are urgent, that are essential, or are time-bound matters. We like to recall that since after April 8th, even in the post-lockdown era, courts are still, at least many courts are still applying the terms of that last CJN's circular. And so across the country, many courts are not taking on in their dockets that have, or that are scheduled to take on those when those cases, on the days of cases. Many courts are not even accepting filings from many litigants at this time. And many people who go to courts now also find out that it's so very difficult to even process process things administratively from the courts, whether they are certified true copies of things and so on and so forth. So that's all been affected by the lockdown. And you begin to wonder, when is the judiciary going to get into its own post-lockdown phase? Because you expect that the post-lockdown phase will begin to address, first of all, will begin to help normalize the operations of the courts. And by normalization, we mean that the courts can begin to take the cases in their dockets as they should on the days when those cases are slated for hearing. But we are not seeing a lot of that. So what we are seeing instead is courts are saying, oh, it's July, we have to go on a regular routine 2 months vacation. And then you begin to wonder, vacation, exceptions, though there are a number of courts that have given up those vacation periods. I think Ogun State, Jigawa State, there might also be others too. But you begin to wonder, how does the idea of taking vacations at this time reflect the commitment of the Nigerian judiciary to actually, deal with the post-COVID-19 situation? We are actually in an emergency right now. Court dockets have spilled over. Many of those dockets are breaking points, already. And there are many vital interests that are tied to some of the cases that are in court. There are people in prison who cannot process bills because, their criminal cases have not been concluded. So, it's difficult really to begin to feel the commitment that our courts have to normalizing the situation. A while ago, I read about a situation in England, where the Lord Chief Justice and the Ministry of Justice have concluded plans to, address the backlogs that have accrued as a result of the suspension of court activities in that country. And measures that they are taking in that country is that courts are now going to work on weekends. They are going to work at nights, and they are also going to work early mornings. Courts are using now buildings that are vacant. In other words, they are creating more courtrooms to be able to do this. And so when you see how other judiciaries have addressed these issues arising from the lockdown, perhaps I should also mention this. In India, the Supreme Court has given up its annual vacations and postponed. They've cut that short and also postponed it because they want to address the backlogs that have emerged from this COVID-19 situation. And I think these are these are like things that tell the story of the judiciary's own conscientiousness. And I think these are the kinds of things we expect our judiciary to do, so that we can, substantiate, our own relevance to society. But that's not exactly what we see when you hear that courts are going on vacations at this time. We really don't have a backlog congestion strategy or program. Everybody needs vacations. The judges need vacations. Even the court clerks need vacations. Lawyers need vacations. Participants vacations. But the situation at hand calls for sacrifices. And I think our judiciary needs to explore its own need to make those sorts of sacrifices. Now, part of the problem, I think, we are in right now is that the Nigerian bar is not, is not calling out people, calling out situations, playing a really active role in mediating how our judiciary should respond to both the COVID-19 situation and the post-COVID-19 situation. And why is that so? I think part of the reason is because we, as an institution, we have not been able, the bar has not been able to institutionally define its own role. And we as members of the bar have not been able to define what our expectations are of the Nigerian bar. I know that Im stated when we started off that, look, we should focus on the bar and the contributions of the bar. I think this is one of those contributions. I think our bar needs to play a much more engaging, active, and stronger role in matters concerning the delivery of justice in our community. So we really haven't interpreted that role very much. I think we see ourselves more like people who consume policies made by, let's say, the judiciary. So we are at receiving end. Whatsoever policies that the judiciary decides upon and they pull these out, we just say, as your lordships please, life goes on with us. And I think that's a rather passive role for a country's bar. It's really not in relation to this post-COVID-19 situation. I think across board, you really see that the bar has practically left the business of judicial reform to the judiciary. And I think that's a wrong approach, because even the judiciary has its own institutional limitations when it comes to designing justice reform policies. Our judiciary consists of judges who are paid to judge cases, not to reform judiciary. And so if we leave it up to them to take this agenda forward, we are making a mistake, because they are going to move at their own pace, not at the pace that is adequate for court users, not at the pace that is adequate for us, who are the lawyers who practice in our courts. And so we keep being at the receiving end, not leading the effort. And when it comes to leading efforts, I can cite a few examples. I don't know whether many of us will recall easily. You see, the American Bar Association, it's a bar association just like our own bar association. They were the ones that developed the model templates that the federal and state judiciaries in America have adopted in relation to ethics in the judiciary. In other words, the judicial code of ethics in America was actually, produced from a template, from a model that was developed by the work of the American Bar Association. In fact, what the ABA did was that they set up a commission on judicial ethics. And who headed this commission? The ABA appointed the Chief Justice of America at that time, Chief Justice William Taft, to head that commission. And that's the commission that produced the current set of code of ethics that's used in most of the states and at the federal level in the US. So here is a bar that's like taking the lead in ensuring that the legal, not just the legal practitioners, but the judiciary in America is able to function ethically. So why can't we do something similar? You know, a judiciary is in a whole lot of, forgive the word, mess. You know, we have several of these challenges, and the turbulence has not eased. You know, some of the events of the last few years perhaps testify to this. So we really we need a bar that can interpret its role as not being a passive organization, an organization of, yes, my lord, business as usual. No, I think we need a really activist bar. And if there are those who are, you know, challenging to lead the bar who are present in this meeting, I really would urge you to do something more. There are two areas actually where I think the bar can play a major role right now. You know, number one, appointments of judicial officers. Okay. You know, this is, I don't know, many of you may have been familiar with the 2014 extant revised guidelines on judicial appointments adopted by the National Judicial Council. Now, we were involved, myself, the MBA, we were involved in, and the NJC as well. We were involved in processes that I think impacted on those sets of guidelines. And some of the very, some of the very progressive things about those guidelines are that it establishes, or at least it ought, that's what it advised to do, a merit-based, transparent, objective, and, you know, sets of criteria, you know, governing access to judicial offices in Nigeria. It levels, or at least it ought to have provided a level playing field for everybody. Not just for people who are already within the system, the judicial system, but also for those of us who are outside the judicial system, so that any one of us who is interested in accessing judicial office should be able to do so. Now, what has happened after those guidelines were passed? You know, not so much has changed, really. And some of the lofty goals of those guidelines have yet to be realized. You know, and I think it's very key. Judicial appointment is so key. Let me read out something I think might help make my point here. This is written by, just a short paragraph. It's written by an American professor of law, and this is what he said. He said, "But the quality of justice depends more on the quality of men who administer the law than on the content of the law they administer. He says, unless those appointed to the bench are competent and upright and free to judge without fear or favor, a judicial system, however sound its structure may be on paper, is bound to perform poorly in practice." So, ladies and gentlemen, I think really that one way to look at what we have gone through for a few years now in the judiciary is that we've really gotten a lot of things wrong with the way we recruit people into the bench. And if we need, at least from a long-term perspective, if we need to begin to address that now, we've got to get the appointment system right. I think the bar ought to insist that we break this hegemony that we find in the outlook of the judiciary. I think the bar needs to break it. I think we need to have a judiciary that is representative of all shades of the ideological spectrum, representative of shades of perspective, representative of different shades of our society, not people who have been there and are being recycled from one court to the other. I think this is where the bar needs to put its foot down and say, no, we will not let things go on as usual. Let me also say this, access to justice challenged a while ago, a few months ago, we challenged the appointments or the recommendations of some justices of the Court of Appeal into the Supreme Court. We challenged that. The court throughout our suit said we didn't have locus standi. Some other people are challenging appointments made into the FCT, High Court in FCT High Court, on the grounds again that there were violations of the guidelines for appointing judges. So the question you ask is, the court will probably throw me out of court and say you don't have local standard, but maybe not the NBA. Why is the NBA not insisting on these things? Why is the NBA not saying no? If there were breaches of the procedures, these guidelines they're supposed to represent, the future of the judiciary. Maybe we should do more to defend that integrity of that system. All right, enough with judicial appointments. Another thing that the NBA can actually also think of doing is, this is again on the subject of delays. Okay, I think in a way, we give the judiciary petty passes. We give them a pass on several things. Delays are caused by lawyers. I agree, the lawyers, but I don't think that if you look at the statistics, it's the lawyers that account more for the factors of delay. A few years ago, the Justice for All program of the British Council did some survey of some high courts, I think in Enugu and the FCT. Part of the findings of that survey was that, when I did some of the analysis, I found out that 65% of the reasons why courts have to adjourn have to do with the actions of public authorities, not defense counsel. Public authorities. In other words, it's either the courts are not sitting, the prosecutors are not in court. One reason or the other besides the defense lawyers. So defense lawyers contribute 35%, while the other causes, the judges, the court, the prosecutors, 65%. So they have more of the blame than the lawyers. And one of the reasons why we actually as we need to keep reframing the argument is that in any meeting where you have judges will almost always put the blame on lawyers. In all the meetings I've attended with judges on the causes of delays, they always say, oh, it's the lawyers. And then they make rules of courts. And those rules punish lawyers. Each time you don't come to court, you have to do this, you have to pay this fine, But how come those rules don't factor the other delays caused by the courts themselves? How come we can go to court and they say the court is not sitting because the judge has traveled for a valedictory service, or that the court has traveled for the funeral ceremony of a judge of that court in the FCT? How come? You know, so some of these things are things where lawyers, the NBA, can put its foot down. The past president of the Court of Appeal, when she was leaving office, she paid a number of valedictory visits to a number of divisions of those courts, including when she was done with all that, another valedictory visit in the FCT, the headquarters of the court. For most of those visits paid to those other divisions of the courts had to shut down their business. I don't know whether out the gentleman who actually called my attention to this some time ago. He's senior advocate of Nigeria. So some of these things happen, and we get these things, and it's not pleasant at all. So to round up, there's really a lot that the NBA, we as lawyers can do. I think first of all, we as members of a community called the Nigerian Bar Association, I think we really need to reframe our expectations of the bar. Then second of all, we also need to ensure that the NBA as a professional body of lawyers is able to recalibrate its relevance to the delivery of justice system in Nigeria. Let the NBA take the lead. Let the NBA take the lead. In 2009, for example, when we, many of you know about fundamental right enforcement procedure rules. This was the work of, mostly driven. It was like, we ourselves and the NBA drove that process, and it resulted in the reform of the fundamental rights enforcement procedure rules. So if you're waiting for the CJN to reform anything, you probably would wait for a long, long time. Fortunately, another legal practitioner is now taking up the task of even getting the 2009 rules, getting the 2009 rules reviewed again. Again, these are things where the NBA, these are places where the NBA, these are grounds where the NBA should be stomping. I think we need to see a rebranded NBA. Thank you all very much.
Sorry, I think I was on mute. I say thank you very much, Mr. Ote, for that insightful contribution. I think at this point we're now in Q&A, interactive session. Mrs. Bumi Ibrahim, please, you have moderation. You have moderation of the session. So members of the roundtable are free to participate through questions, answers, contributions to discuss the subject matter and some of the highlights that have been brought to our attention by the lead speaker so far. You can either indicate through the chat box, or you can have your hand raised. I believe Mr. Bayak, let's see, we have 2 questions. Mr. Bayak, I believe, has his hand raised up. Yes. Mr. Akinlade and Mr. Abiola Osho, permit me to, sorry, Mr. Abiola Osho, Permit me to allow Mr. Abiola Osho contribute. That is AL members. Mr. Osho, over to you. Can you unmute yourself? Mr. Osho.
I'm sorry, I didn't really have a question. I must have pressed the raise hand button in error.
Okay. All right,
I'm
then.
sorry about that.
No problem. No problem. Who has a question or a contribution to make?
I have my hands raised.
Oh, beg your pardon. Sorry. Yes. Carry on. Emeritus Chairman.
Thank you, Mr. Ote. It's always good to hear from you regarding access to justice and the position of the MBA. In my capacity as chairman, I tried a lot to interface with the judiciary and the Ministry of Justice and other arms of government when it comes to what how the judiciary should function. But I had a lot of pushback in terms of corruption, where we all know that. In terms of reform as well, there was a lot of pushback. I recall when the list of judges came out, and I decided to put that list on my branch WhatsApp platform to say, okay, MBA members, these are the list of judges. I got a lot of heat from judiciary from that, but I stood my ground. They wrote me a letter telling me that the list was confidential to the chairman of the branch. And I responded with a letter to say that you cannot ask that a letter, the list of shortlisted judges should only be seen by the chairman of a branch and to comment on. And I refused totally to accept their position. And I said, because I'm in the Bar Association, I am not subject to their internal policies in the judiciary. The next time they brought a list, they reminded me again that it was for my eyes only. And basically what I just did was I just threw the letter away and filed it. I didn't even attend to it, and I didn't even care at the end of the day who they decided to select. But my problem is a lot of the members of the Bar Association are clueless, or they choose to be clueless. They're silent about these things. And until members wake up to stand their ground when it comes to this profession, I think we're just a long way off. So I don't know if there's another way to confront these issues or not. Thank you.
Thank you very much, Mr. Akinlade, for your contributions. Any questions or contributions to the subject matter?
Yes, Imran, Professor Abiola Soni had his hand up.
Yes, please.
Prof, over to you.
You're in charge of this moderation.
Yeah, thank you very much, Pius. Now, I don't know what the statistics are saying about the causes of delay, but if you ask a reasonable man on the street, they will finger the lawyers. Right or wrong? A lot of people believe that lawyers are the problem. Lawyers are responsible for all the problem in the justice administration system. Such a generalization can never be true. But it then behoves lawyers to try and do something about it. Because if lawyers cannot solve their own problems, how do they solve the problem of the society? So I think this is an auspicious time for AAL to try and put something together which can be a program of action for MBA. Because it's not enough for us to say MBA has a role to play, MBA must lead. We can give them fundamental principles and directive policies on what they should do. And as far as I'm concerned, all aspects, beginning from commencement to execution, will require reform. How do we access? I understand that access to court is not the same thing as access to justice. But yet, accessing the court is riddled with so much technicalities. So we have court of technicalities and not court of justice. There are cases that should be filed just by filling a single form. I don't think we have any simple process anymore, even at the magistrate court. When we were in school, what they taught us was commencement by plaint. And plaint is just like a letter. I don't think that is what we have in the magistrate court anymore. So, and I think we can borrow a lot by looking at the rules applicable to arbitration. Because to commence a matter, you have a lot of bottlenecks. To serve, you have a lot of bottlenecks. There are rules in arbitration that have simplified some of this procedure. And I think we should be audacious to even try to have a timetable for, so that we have a rough idea when an action will end. Why commence an action and you don't even know when it's going to end? I don't think this is rocket science. So what I'm saying in essence is that there have been a lot of talk around this issue. Joseph Otte has even devoted practically all his professional life to this. So we all know the problems. So the issue is, let us identify what lawyers can do immediately and put it in the hands of NBA. Maybe access to justice and AAL can work together in this regard. Thank you.
Thank you very much, Professor Sonny. You raised one issue that I think we need to address as lawyers, and that is the fact that for some of our colleagues that engage in filing these frivolous matters, delaying matters in court, and generally behaving very badly, it's because of the financial incentive. It is profitable. A client is paying them to take a matter to court that they know doesn't have any legal basis. So you have a defendant that is forced to employ a lawyer to defend a, quote, useless case. So when we're talking about the MBA, I think one of the things that we as a profession will need to do is find a way to safeguard our territory, so to speak. Because we have members of the public, at least when some of us started practicing, if our client sells a plot of land or sells a property, the purchase price or the sale price is kept with the lawyer. But I can make bold to say that nobody today will sell land or sell a property and the price goes to his lawyers. That's how far we have fallen in the perception of the general public. There is no trust. So I think one of the things we need to look at is how our national body can ring fence our areas of competence. You have members of the public who somebody is owing them money. Instead of going through the usual debt recovery process, a civil matter, they will go to the police station, see the DPO of the police station, and that one will take 10%. If you have a land issue, you would rather go and instruct a thug or the neighborhood omonile instead of instructing a lawyer. These are all issues that we need to discuss and to come to a realization that unless we market ourselves and are seen in the general public as professionals, as people who add value, some of our colleagues will say, we're just talking grammar, and they will continue the kind of acts that they have been doing And when the public wants to talk, they will say, those lawyers, meaning that you and I and everybody on this forum has been grouped together with those lawyers who do all those kinds of things. So I think one of the things that we should look at is, should we persuade the judiciary, for instance? There are provisions concerning costs. Should we, as a professional body, insist that those costs, when they are awarded, should maybe be on an indemnity basis to discourage our colleagues who take such useless applications and so on to court? Do we make them personal, so that if you have a client that keeps on filing all these cases, then award heavy cost against him? We need to do something radical. That's what I'm hearing from Professor Sonny and the last person that spoke. And I think also we need to be aware that we are operating in a society that the ethics and the morals are at the very, very bottom. And we lawyers are not operating outside society. We are part of society. So if I see something wrong and I complain, just like Mr. Akinlade said just now, I'm the chairman of a branch. You send me a letter and I publish it to the members of my bar who elected me, and you tell me to keep it confidential. Who is my responsibility to? Who are my constituents who elected me? Is it not the members of the branch? What responsibility do I have towards the bench? Why should I keep it confidential? So we talk about ethics. If I write a petition against my colleague, or I write a petition against a registrar, or I write a petition against a judge, what happens? I'm branded a troublemaker, and my client may suffer from that action in future. But everybody else might be dealing and going along with the normal situation. So they will benefit from the action that I take, and the client that is paying me may lose. So I think we need to put these things down in this webinar and come up with solutions and come up with things that we can put forward to the body that is representing us, so that we can effectively make that change. Mr. Shofalawan, your hand is up. Over to you.
Good morning, gentlemen and late gentlemen. I'm sorry, I think, oh, did I say morning? Sorry, good afternoon. I'm sorry, I think it was an error in raising my hand. I just joined the program about a few minutes ago. So, but basically, I want to commend you for the program, and I'd like to participate, even though I'm not around at the moment, but that's the whole thing. Thank you very much.
Mr. Akinlade, I have a question for you. I know you've done a lot of you did a lot of projects whilst you were chairman of the Ikorodu branch. What was the general perception of lawyers from your public interaction with them?
At first, well, they didn't trust us. They thought that we were only coming to, just do the normal talk shop. But when they started benefiting a lot from our interaction with them, in fact, we started getting referrals from even the government. We got referrals from the KBC, we got referrals from the local government, and we found ourselves working every week in different committees, to help sort people's problems out. So in the Ikorodu community, things actually really changed, and the public perception of the bar station had, gotten to a very encouraging level within the community, that we even had less people going to the police stations to get matters resolved, and they were actually coming to meet us at the Bar Association. So that's where we are, and we're still doing that. Throughout COVID, we were engaging in a lot of domestic violence cases. We're engaging in a lot of cases where people were taking each other to the police station. So it's a lot of work at the end of the day for our members, but at the same time, we have good feedback, and we have more lawyers getting jobs now instead of the police and other people.
So the demand for legal services is there. That's what I'm hearing you say.
Oh yeah. I mean, like I said, our lawyers work every week now in courts, in committees. So demand is really high for lawyers in Ikorodu. And it's it can really get exhausting, especially because we're doing most of this pro bono. But the advantage of this is that clients are exposed to new potential, our lawyers are exposed to potential clients from different walks of life around the Ikorodu community.
And your community is less urban than Lagos.
Oh yeah, sure. It's a mixture. It's a mixed breed of partially urban and a very traditional local. So and it's highly residential. So which makes it less commercial, but a lot of domestic issues is what we try and resolve. Of course, there's a lot of land litigation in Ikorodu as well, but that aside, it's more of domestic issues, small crimes, petty crimes. That's what you find in Ikorodu. Although we had the issue of cultism as well, which interestingly, MBA Ikorodu is also taking the lead in reforms in that area. We've connected with the community, with the traditional community. We're bringing everybody together to try and have an anti-cultism seminar conference in play. But because of COVID, unfortunately, a lot of that had to die down. But this week, we're actually doing one on rape, as rape is a crime. It's a 3-day program. So it's one of those things that we do constantly to get the community engaged, to let them know that the legal community also cares about them. We also, of course, in partnership with the the medical profession, and we try also to bring in other professions and government agencies. We work closely with them.
Thank you. I'm going to ask the Honorable Attorney General of Lagos State, Mr. Onigbanjo, Senior Advocate of Nigeria. I want to come to you now. Lagos is the most urban city, and in fact, it's the capital of West Africa, so to speak. We have, some say 20, some say 22 million residents. And in the past few years, Lagos has actually sat down and designed an access to justice framework. It's as part of trying to stop everybody rushing to court. So we have the Office of the Public Defender, we have the Citizens Mediation Centers, and then we have the Lagos State multi-door courthouse. So I'd like to ask the Honorable Attorney General, what else does Lagos State have in store? That's the first question with respect to access to justice. What else is new in Lagos State concerning access to justice? Then the second question that I would like to ask you, and I know I'm putting you on the spot, is just to give us an idea of, number one, the percentage of those matters, whether it's at the CMC, OPD, or the Lagos State Multi-Door Courthouse, that lawyers take part in, and what has been the general response by lawyers to those measures.
Thank you very much. That is really putting me on the spot. What is new in Lagos State with access to justice? So one of the new programs that we're initiating is what we call restorative justice. This would ensure that it's not all petty offenses that are charged to court. So if you have somebody who, for example, stole maybe 500 naira or something, also petty crimes generally, misdemeanors. So we don't want to clog the dockets by charging all those people to court. So for example, if you maybe stole somebody's bicycle and you're ready to restitute in terms of either if the bicycle is still with you, returning it or buying another bicycle for that person. So we're going to provide that mechanism. It's called diversion. So we want to divert a lot of cases away from the courts. If we succeed in doing this, the courts will be freed up for a lot more matters. This diversion, as you very well know, is currently going on in all our police stations nationwide. Because many a time when people go to report at the police station, you know, the police will say, okay, settle it this way, go and bring the money, do this, do that. And they, you know, most times they're settled, the matters don't get to court because either the family of the accused defendant intervenes and the victim is also satisfied with the restitution he or she gets. So those matters are never actually charged to court. So we have a unit which is going to deal, or which deals with this already. It's called community services. We're also strengthening our community services. We've given a lot of training to magistrates, even to police prosecutors, to adopt all the mechanisms available. Plea bargain is also one of our restorative justice programs. We've noticed from statistics that there are very few plea bargain applications from the magistrate courts. So I believe about 2 weeks ago, we had a webinar with the Honorable Chief Judge of Lagos State and all the magistrates. We had some NGO partners who came to speak to all of us about the benefits and advantages of plea bargain and how to use it. Because the bulk of criminal cases come from our magistrate courts, and it's therefore surprising that very few applications come from magistrate courts. So if we are successful, we are looking to take between 20% to 25% of the caseload off the courts by successfully diverting the cases and then freeing up valuable judicial time and resources to take more weighty matters. Your second question, maybe you might just want to remind me what the second question was about.
Yes, the second question was about the participation of lawyers in all the in the ADR, whether it's at OPD, the multi-door courthouse, or at the Citizens Mediation Center, because I was told that some of our colleagues were saying that, this will be taking jobs, quote, from lawyers.
Yes, thank you very much. In fact, one of the constraints when you talk about the when we talk about the pros and cons of ADR, we find that mediators always complain that lawyers make mediation more difficult at the multi-door courthouse. For some reason, most of our colleagues mentally are geared towards believing that you can only charge full fees in a full-blown litigation matter, a matter that goes to court and is full-blown. So they tend to discourage their clients from accepting settlements at mediation. They've somewhat become a clog in the wheel in that regard. And the multi-door courthouse and the Ministry of Justice are also sensitizing, even the CMC, which is the Citizens Mediation Center. We do a lot of sensitization programs, trying to reach out to the clients themselves to tell them that, look, you can have your matter resolved in a comfortable and convenient atmosphere. The parties and the mediators, sometimes that's why you see mediators ask the lawyers to excuse them to allow them talk directly to the clients. So to that extent, we need to have a culture change and adopt all these ADR measures wholeheartedly in order to allow the courts reduce the very heavy dockets, which in itself is one of the biggest constraints to access to justice, which again is also one of the reasons for delay in court processes. Because imagine a judge who comes to court on a weekday and he has 30 to 35 cases on his docket. There is no way that out of those 30 to 35 cases, some will have to be adjourned because the judge will either be physically or mentally tired and cannot devote the same level of concentration on every matter. So at a certain stage, there's a mental block and the judge will have to adjourn. So ideally, if we can take it to a situation whereby each judge has about 5 matters a day, then we can all see that it will be easier for that judge to take those 5 matters rather than when he comes and he has 30 or more cases before him. So all in all, we as lawyers, we have a big role to play in really ensuring that access to justice takes prominence and the pride of place that it ought to. We shouldn't become the problem. We should be the solution. Right now, unfortunately, we are more part of the problem than the solution. And so we need to look inwards. Part also of the problems, again, is the lack of speed in the disciplinary process and also the lack of awareness. Most of the things that our colleagues do, they will not get away with it in other jurisdictions. But they do it here knowing either there will be no consequences or that even where there are consequences, because of time, the complainants get fatigued, they get frustrated and abandon the process, and the lawyer goes scot-free. So we need to look at all those issues. Excuse me. We need to look at all those issues in total to be able to make some traction forward. Because I mean, you know, if we put in place all the laws, we put in place all the facilities required, but the players, the main players, do not cooperate, we will still not make progress. So the
It's just
buy-in of everybody is...
Just to buttress what you were saying about the lawyers being a really important part of the program, of the whole system. You have the judiciary, you have the bar, you have the parties themselves. And if just one of that tripod refuses to participate in an honest way to resolve the dispute, they can scatter the process. Now, I live and I practice in Lagos, and the courts in Lagos State, they are extremely congested. I want to give an example of a litigation matter that we did that went very, very well. We filed a matter in Ogun State, Shagamu Division, matrimonial matter, divorce matter. We filed that matter in November. We came up before the judge in January, and the judge set a date for hearing in March. Now, March, we all know what happened in March. There was lockdown. Nothing was going on. So that date was vacated. And then the registrar contacted us and gave us a date for hearing at the end of June. Now, June, we put our witness in the box. The other side did not cross-examine. They did not lead evidence, and which was surprising to me. And there, my junior addressed on points of law, and the judge adjourned for judgment to July 28. So from filing in November 2019 to judgment in July 2020, that is just 8 months, because we had a judge that was firmly in control of his court. We had the respondents' counsel who was doing his job the way you expect a lawyer to do his job. And then we had the parties themselves that cooperated. So it can be done if we all cooperate, and there must be sanctions for those that don't cooperate. Professor Sonny, I see you, you're next. Over to you.
Thank you very much, Bumi. Before I go to my major point, let me just speak to what Akinlade said about Ikorodu. I'm a friend of that branch, and I know the extent of the great work going on. And there is no doubt that during Akinlade, courage defined their activities. You know, audacity and courage and all that. But if you reflect on it more carefully, I think you should have shared the letter the second time. Because what you were doing, your principled position, was the right thing to do. So they were the one who is wrong, and it would have been better if they stopped sending that letter to you or to your branch, rather than you shredding it and all that. So it's not too late. I think you can speak to whoever is succeeding you to sustain that, that practice that you have started. No doubt you have sent the right signal and you have sown a seed. You never can tell what the tree will become. Then, having said that, I think the manifestation of the delay is even worse at the appellate court. The higher you go, the more the headache. I don't practice much, but the few appellate cases I have at the Court of Appeal at the Supreme Court, I can tell you that even after writing the brief, you would have totally forgotten about the case before you get to hear to get a hearing notice. Some may take 3 years, some may take 4 years. I don't think any serious system should allow this to happen. So we need to actually be serious about keeping the gate. Keeping the gate at the commencement of action and also keeping the gate at the appellate level. I doubt if we are able to start and finish this at this webinar, but at least we can identify that we want to resolve this. There must be consequences for filing frivolous action. There are practice and procedure for discouraging this and dealing with this elsewhere. You can't just go to court with a matter on which there is plethora of cases and say you just want to test it. So like in arbitration, if you take a frivolous matter to arbitration, subject to parties, you have to bear the cost. So if we have similar rules, what is happening relating to cost of litigation, where we approach it is wrong, because basically people will just claim an X amount of the cost of litigation and no pleading. We do not bother to plead, even the fees, the payment and all that. So we have to do something and ensure that those who fight frivolous actions bear the cost. Because when you drag an innocent man to court and he has no choice than to defend and defend at great cost. At the end of the day, you can't say cost should be in the cost. So we should look at this and look at what is happening elsewhere, come up with options. By the time we start debating some of these options, we should be able to consensus around them, because people will tell you that it's also part of access to justice to file whatever action they feel. Some do it because they want to add to the number of cases that will give them the silk. Some do it because if they don't go to court, they don't hit. But what I'm saying is that there must be consequences, and we don't need to look too far before we find an appropriate solution. Thank you very much.
Thank you very much, Prof. Sheyi Ojo is next.
Okay. Thank you very much, me. I just wanted to offer some insights into what the Honorable Attorney General of Lagos was saying about mediation, or more, make a comment about your question, some kind of comment on the question. I happen to be one of the neutrals at the Lagos Multi-Door Courthouse, and I've done arbitrations and mediations in the past. And I can quite relate with the issues that you have raised about the perception of counsel that the mediation exercise is effectively killing the goose that has laid the golden egg, and how they tend not to be cooperative. And I have often advocated, even though I haven't attended any in the recent past, at mediation parleys, that one of the ways to go about this is to ensure that counsel are themselves engaged. What do I mean by counsel being engaged? Maybe because I also practice law. So when I sit in my role as a mediator and I realize that the party can't seem to take a decision without the counsel, I will then engage the counsel in taking that decision for the client or advising the client. I charge them with responsibilities. I have often said that it is not a right approach to tell counsel to just walk out of the room, that this is the party's dispute. While it is true that it is the party's dispute, we live in an environment that is heavily litigious. And insofar as there is a dispute, most litigants and disputants can't seem to take a decision without their counsel. So telling the man to walk out of the room or the lady to walk out of the room might end up being counterproductive. And I dare say that in many a case, this is the reason that we find people complain about the mediation process not being effective or efficient. So one of the things to do is, even if you want to exit the council, endeavor to see how best you can engage the counsel. There are some cases that are so pathetic, because I once had a mediation where the counsel was the problem. The claimant had what appeared to him to be a good case until the respondent came and we saw that there was a glitch somewhere, and it was at the claimant's doorstep. But because the counsel had fed the claimant with so much boosting of confidence and whatever, I don't know how to best put it out. You had a situation where he found it difficult to make a concession and he was being adamant. So I ended up having to close the mediation because I knew that what had come out in mediation was certain to come out in court, and he will be the loser for it, even though he's the one that filed the case in court. In terms of what to do, and that was, sorry, if I may just share a brief insight into this so that you can understand what I'm talking about. This is a gentleman that borrowed money, about 200 million from the bank. He paid the money, but you know, in banking transactions, interest elements will not drop until the end of the month. So he paid the money middle of the month, assuming that he paid everything. And then at the end of the month, there was an interest element that dropped, maybe about 3 million or thereabouts. And he didn't pay, he didn't realize. Later, this was May, later sometime in maybe September, he gets a letter from the bank saying that he's owing, I can't remember now, maybe about 5 or 6 or 7 million, whatever, as of March. So he was peeved, rightly so, that if I have paid money as of March, why would you, as of May, end of May, why would you tell me that I'm still owing this money as of March? So he rightly ignored it. Now, the whole thing went on. It got forensic auditors. They went to the bankers committee. They then went to court and they came to mediation. The lawyer had been his man Friday because he had sued the bank and sued the bankers committee that had given an initial decision to him. And the lawyer came and just streamlined and was making progress in court until the court referred the matter to mediation. Now, when we sat in the session and we threw it at the bank that indeed it doesn't make logical meaning, the bank then comes back and says, oh, come, let's look at this for a minute. This person is saying the truth. Let's look at our papers. Then they looked at the papers and they realized that the letter that was written to him saying as of March meant to say as of May. But it's a letter, is a template that was written that did not change that date. They realized, looking at his account statement, and he even took out the account statement, the same account statement that went to the bankers committee, and they realized that he owed this money. So it was so obvious. I felt, and this is me as counsel, and I couldn't throw it out there, that what you should start talking to the bank about is that it's your error. Okay, so I don't owe more than 3 million. This other money that you're telling me I'm owing was because of what you did. But the lawyer had given him some blind confidence and he felt, and he had that problem. When I caucused with him, I told the lawyer, can you excuse us? And I gave the lawyer something to chew on so that at least he will justify his paper. So there are some cases where it is near impossible. Now, what do we do moving forward to ensure that we at best reduce this to its barest minimum? I know that the Lagos Multi-Door Courthouse had done sessions that I think they'd invited resource persons on what you call mediation advocacy, which is a program intended to get the lawyers on board for them to understand how and what role they can play and how they can still benefit even from that process. They've done it in the past. I know the Chartered Institute of Arbitrators has a pact with the Lagos branch of the MBA now to run courses, which was frustrated by the COVID experience. But they had had an agreement, a memorandum of understanding to run courses at a lower sum than the institute normally runs. So at least give people clear insight into what the arbitral process entails and how we go on about it. I remember when I did the mediation skills course, a judge of the Lagos High Court, who also was on that course, asked me, so how will this be for you? Because evidently lawyers make money from the case and all. Just generally trying to sound me out on what I thought. And I said, no, I don't look at it that way. One less file on my desk leaves room for another file to come in. And so half a deal is better than no deal. I stand to benefit nothing if my case lingers in court in perpetuity. Again, it comes back to what we said earlier. A lot has to be done, either in terms of training the lawyers. The Honorable Attorney General talked about the mindset change. The training of lawyers is very key. The disciplinary machinery, we need to start infusing it, even if we have to find a way to start advocating it at a branch level. The courts have to take a more proactive step. I sit on the ethics committee of the Lagos branch of the NBA, and I find that we get petitions, and some judges have actually petitioned against counsel. That we need to have more of that. We need to have them looking at those things. Otherwise, we'll be where we are. Bumi, you talked about the case that you filed in Shagamu in November, and you're expecting judgment on the 28th of November. Again, I dare say that it's a function of, yes, the judge, but sometimes the judge's hands are tied. I have a case that I filed in that same Shagamu, a divorce matter that was so clear-cut that was filed in November 2014. A senior advocate came in response for the respondent and filed objections that even I would not file. And it was dismissed. He will say this, that case has been there since 2014. It has not seen the light of day. So we're where we are because of the characters that drive the system. That's why earlier on when I spoke, I said the system is only as efficient as its drivers. We do not have proper sanctions. The minute the courts begin to apply those sanctions, of course, the corollary is that the courts themselves have a collateral duty to ensure that they themselves are upbeat. So if we all know, we've practiced law, we all know that there are certain judges whose courts we attend. When I'm going before this judge, I know that this judge is not going to faff around. Pardon my French. I know this judge is not going to faff around. This judge is not one that will suffer fools gladly. And this judge is one person I really don't want to run against because this person wants to work. At the same time, we sit in chambers and we're told that our case has been assigned to a court and we can say without batting an eye that that case is not going to go on that day because we know the judge is going to find a reason not to go on. So it comes back to the people. But mediation and arbitration are ways to go, but arbitration is not an escape for litigators, which is the error we have. People feel that, oh, because of the frustrations that we're experiencing in this court system, let's do. So they take that same toga into the hearing rooms in arbitration. The same thing applies to mediation, but there has to be a fair balance in the mediation. It's not about telling them to walk out. Before you have them excuse themselves, educate them, give them rules. If there are legal issues, can you, Mr. X, consider how we can wangle this thing and see how best we can do it for the clients. That way, when they prepare their invoice to their clients, they will actually describe the role that they played. Because as a mediator, the first thing you tell the parties is that, mind you, it is your dispute. It is yours to resolve. You will resolve it very well. That's my comment. Thank you.
Thank you very much. Imran is next. Imran? Imran, you're next. It seems like Imran is not ready. All right. Shay, you spoke about you spoke about, I think it was the Honorable Attorney General spoke about lack of speed and awareness of the disciplinary process. As he was talking, I went online and I Googled Nigerian Bar Association, LPDC, Lagos branch, and absolutely nothing came up. So members of the public, they're not aware of the remedies that they can have against lawyers. But I was just trying to think out loud that if I've had a matter in court and the judge orders costs in the cause, what's my remedy? I mean, I've had to come to court because somebody sued me, engaged a lawyer, I've won that case, and then a judge awards me 20,000 naira. What am I going to do? Because certainly I have not paid my lawyer 20,000 naira. Now, the next time that that gentleman has a dispute or something that needs legal advice, I'm not sure that he will even bother going to talk to a lawyer.
Can I offer a comment on that, please? On the first one about the disciplinary committee, as you're aware, the structure of the MBA, and I stand to be corrected on this by any other member of the listening audience. The structure of the MBA is that disciplinary matters are dealt with at the national level. But the branch tries to introduce this for themselves. So what we have done, and I'm certainly going to pass the message to the chairman, because I'm not too sure how regularly they update the website. This is coming to me new. But what we do is that we look at the petitions and try to treat them and try to bring it home. Call counsel if we feel that there is a case to answer. Call counsel and say, look, is there a way you can go back to this client and resolve this matter? That is if we find that the counsel may have been found wanting. At least on a face value case, we look at it and invite the counsel over. And when the counsel explains the position, there is a panel that says, look, at the end of the day, we think you should go and deal with this. Now, if the council doesn't deal with it and we feel that there is a case to answer, then we can send it to the national body for them to be doing. But unfortunately, it's going to be a long and arduous process because they then start their own review process. But what we do is try to keep it at a very simple level and get them to do it. Now, at the beginning of the current tenure, I think the chairman found there were about 22 cases thereabouts in Lagos branch, and my panel within 3-4 weeks dealt with 11 of them because it was split between two panels. But to say that
22 matters in a city of 22 million.
Well, the petition
against
council is what I'm talking about.
Yes,
that we had to deal with. Don't forget that this is Lagos branch.
Yes.
So this is just a branch. I am not talking about a Korodu branch. I don't know what they work, how they run there. I don't know if they have. I'm not talking about Ikeja and I'm not talking about Badagry. At the same time, don't forget that some people just throw their petitions also to the national. They don't go through the back branch. So it might well account for why you have that low number. But that's what we do. Now, we've dealt with those petitions already. Another wave of petitions came in as of last week that we're also going to look at. But coming back to your point about the website, I think it is something that will be looked at. Now, on the costs that you talk about, I think it is unfortunate. I also happen to be a member of the faculty in the Chartered Institute. And one of the things we talk about when we talk about costs and interests is that the cost regime in our court system is actually the bane of litigation in Nigeria. The fact that I will spend this much of my resources to pursue a matter at the Supreme Court, and ultimately I will not be given more than 30,000 or 100,000 is most annoying because it doesn't begin to assuage the pain that someone has felt in terms of expending those resources. And we need to look at it. Now, the rules of court I can't remember which order now, try to introduce what happens in England, where if there's a protocol, whether however strong you feel your case is, you must make an effort to resolve it. If you do not resolve it and it goes against you ultimately, it is going to be taken into account when you're dealing with costs. Even if you win the case, the mere fact that you have not lent yourself to the process of mediation or to try to resolve it may count against you in costs. However, that is looking at a cost regime that is also intended to be, I won't say punitive, but at least to deal with what you've just talked about, right? Now, our judges, our courts are still to embrace it. Our courts are still to embrace it, and we need to encourage that to happen. There's a case called Elgin Data number 2 in the UK, which makes it abundantly clear how the costs will work. I have done judicial reviews in the United Kingdom, and I remember it was an immigration appeal, and the instant the court in England granted leave, just leave, and that's what fits to the point I made earlier on about leave should not be routine. The instant the court in England granted leave to the litigants to apply for judicial review, immediately the respondent called to resolve it. Because the respondent knew there and then that what was placed before the judge is concrete evidence. The judge has probed. And so if they don't have anything, or if I have not withheld anything, and it is on the same strength of the same evidence that the main case will be considered, they will be quick to call you to try to resolve it. And even at that, they will pay costs. I've been in cases where they have paid as much as £3,000 in costs for a judicial review at the stage of a leave application, because they know better than to go further. So if our courts do not begin to deal with it that way, and deal with it with the litigants, and as far as the counsel is concerned, apply it on counsel to filing frivolous applications, then you're trying to reinvent the wheel. Somebody says you want to explore the frontiers of the law. To do what? At what costs? Where somebody is taking an appeal, the court should sit down and say, tell me, Mrs. Ibrahim, tell me, where are we going with this? There is case law that has settled this point. What is the new thing you're trying to do here? And as long as we don't have our courts doing that, and I'm not trying to put anything on the courts per se, the judges are lawyers. We all come from the bar. So at the end of the day, it's a multifaceted problem that we need to deal with. But the cost regime is actually the bane of legal practice. Once we make sure that sits in well, you will find out that people will be afraid to file applications. That is what happens in civilized crimes. It's just what happens. Sugarbar and Union Bank of Nigeria, many years ago, there was a case that was dealt with that said, if a court awards cost against you, before you file another case, you must go and pay that cost. You must go back and pay that cost. Now, I don't know if the decision was overruled as saying that it was depriving somebody. Somebody is going to go and fly Section 36 and say, oh, my right of access to court and this has been frustrated by this. But we're not looking at the principle behind those decisions, because these things we talk about now are the very things that those kind of decisions try to address. So that, I think, is where we're going. I agree with you. The cost regime needs to be revisited. It doesn't have to be punitive, but it has to be effective. It has to be effective. Justice Augie, when she was at the Court of Appeal Lagos, told the council that I will not, it sounded when she was saying it very high-handed. But she said, you will not do any matter in the Court of Appeal Lagos Division. I will not hear your matter as long as I am here. That was her own way of sanctioning counsel, because the disciplinary process is so long and you will get a lot of things done while that is still waiting. But now, if you have appeals, your clients are the ones that are going to suffer. They will debrief you. But we need to be innovative about it and try to put new things to it. But I agree with you. The cost regime is the issue, and I'll pass the message to the chairman of the MBA. Thank you.
Thank you very much. Tokunbo Jayaguru is going to speak, and then Imran is going to wrap up for us. Thank you.
Okay.
Sorry, Tokes.
Yeah.
I think I'm going to, I'll just want to just highlight some key points that have been addressed at this roundtable, and then perhaps you might take from that
Okay.
in concluding for us. Of the questions that have been raised under the subject of access to justice, it has been clearly made understood that us as legal practitioners no doubt have a big role to play in the speedy dispensation of justice. But however, there needs to be, it has been, it's quite clear that there needs to be a mindset change, a change of behavior, a change of attitude. That is for us all to agree that indeed we have a role to play and there is an expectation of us. Now, that takes us to the next point that has been identified, that how would we now make us to accept this responsibility and change, whether we like it or not. That takes us to the cost regime. That is, a cost regime must be put in place to ensure that we lawyers accept this responsibility. And of course, that has been said that there has to be punitive, there has to be consequences for our actions in bringing frivolous actions and also in delaying. So that's the second point. The third point, I'll call them to-dos, that things we actually need to go from this roundtable to do, to advocate for in doing. So we've talked about accepting our role, to a cost regime to ensure we comply with our role. And then the third point, which was in the list of questions, is the timelines. Perhaps there needs to be a timeline for the duration of litigation from start to finish. And then finally, how can the NBA help us to achieve this? How will the NBA lead in achieving this? Of course, Mr. Shalauji just said that he will speak to the chairman of the NBA. So obviously, what we're doing here is to put together a to-do list and to hand it to our NBA and say, this is what we would like you to do. This is what we expect you to do. And hopefully, we can begin to achieve progress towards, access to justice. So those are the key points I've just that has come from this roundtable. Over to you, Mr. Guru, to round up and conclude for us as not only a member of Ask a Lawyer Forum, but also a trustee of the Ask a Lawyer Forum. Thank you.
Thank you very much, Imran. And thank you, everybody who took time out to attend this webinar. All the points are very germane. The cost regime, I think, is very, very important. As everybody has said, the deterrence of our colleagues from filing frivolous applications we can't say more about that. It is very, very important. I was just going to mention something on the disciplinary committee that Bumi and Mr. Ojo spoke about. We had an issue where a client of ours, by himself, voluntarily, a chartered accountant, petitioned a very senior lawyer. And what did the lawyer do? He filed an ex parte application to sell a property where this man was living. And somehow the court granted it. And he also fabricated evidence, such as lying that he had posted the leave to sell on the property when he didn't. Anyway, the long and short is, when he got to he tried very hard to make me write the petition, but I didn't. But he wrote it himself. When he got to MBA National, they told him that the committee had not been empaneled. This went on for about 6 months till the man lost interest. Eventually, they called him out of the blue to come in and move his petition or argue his petition. He went with some lawyer whom I don't know. But what came out from there, they told him, oh, since these issues are also matters that are part of the appeal, they can't take it at all, that the matter is closed. And this is a chartered accountant. And he said to me, Tokumbo, listen, where I come from in my profession, this can never happen, ever. If a fellow of the institute behaved this way, within 2 weeks, will have been disciplined and out. Now, what is going on with your profession? And he lost interest and he abandoned not only the disciplinary committee, he abandoned the case as a whole. And it's very disheartening. So it's very important that the MBA get their act together, both national and branches, so that we as a body, we know where we're going, we make this profession interesting, we make it effective so that the man on the common streets will come to us for help. I think that's basically everything. So Imran, do you want me to do the vote of thanks, or you can let me pass over to you?
You can pass it on to another member of Ask a Lawyer.
So basically, those are my few
yes.
contributions.
Let me see who will do vote of thanks for us. Tokes, you can do the vote of thanks, I suppose. Yes.
All right.
You have the mic.
On behalf of Ask a Lawyer, the trustees, all our members, the attorney generals that took time out, I know they're very busy to attend the webinar, all our friends in law, we thank you all for attending. We hope that this was enlightening and learning events. And I'm sure we will get across to you on our communique. We don't like to talk alone, we like action. So we're going to take this up with the necessary people, the necessary bodies that can make a difference. Once again, I thank you all for attending and I wish you Godspeed. Thank you.
Thank you very much. Perhaps we should have a closing prayer since we started with an opening prayer.
Sorry?
I said, perhaps we should have a closing prayer since we started with an opening prayer. So carry on. Carry on.
Who is closing for us?
You are.
Can. Alhaji Tokes.
Okay.
Jai.
Thank you. In the name of our Lord, most gracious, most merciful, we thank you for today. We thank you for giving us the opportunity to sit here and listen. We thank you that we are all well, and we pray that we keep well. We pray that you continue to keep us safe. In your special name, we pray. As we go, well, we are home. I was going to say as we go home. We are home, I hope, and continue to keep us safe, oh Lord. Thank you.
Amen.
Thank you, everyone. Thank you, everybody. Shall I just say that previously we had presidential candidates billed for this program, but there was a release, a communique from the electoral committee of the NBA that placed restrictions, in fact, placed a ban on anything that would resemble a debate. So to have all three of them in the same place, it would have resembled a debate. And each one of them has been in touch. And in fact, I just got off the phone of Dason, Deacon additional. So we have been advised to send a letter because they are very, very keen and they really want to come together to address the subject of access to justice. Before the webinar started, Oluwapata, was on the phone with me, and I also spoke to Chukwuka Kwazam, who is the campaign manager for Ajibade. They all are keen to deal with this subject, but they are obviously, for obvious reasons, no one wants to cross the line as far as ECBN is concerned. As a matter of fact, one was asking me, is the other one there? If it's not there, I cannot come, So anyway, we've been asked to send a letter to ECBN. We'll send a letter to them on Monday because they still want to have this session. So We might still have a part 2 of access to justice. It's just under 2 weeks before the elections. If ECBN obliges, then we will have a part 2, access to justice, where we'll focus on the presidential candidates mainly. In the words of Dikin Dele Additional, he doesn't just want to come and speak hypothetically. He wants to come and talk about what he is ready to do about access to justice. So definitely, we will still be on this subject. So perhaps we will, hopefully, I feel confident that we're likely to have a part 2, because you can't have an election without debates. It's really strange. This time last year, we already had one. So I'll leave us with that. I thank everybody for being here, and wonderful deliberations. Thank you all. Thank you so much. God bless.
Thank you all. Bye-bye.